Assalamu alaikum wa rahmatullahi wa barakatuh. I greet you with the universal greeting of peace with you. Peace be upon you. Rabbi shrah li sadri wa yassir li amri wahlul uqdatan lisani yafqahu qawli. My Lord, I ask you to expand my breast, make my task easy, and do the knot in my tongue so that my speech will become comprehensible. I am Riaz Ishmael, and I will be chairing the CPD meeting tonight. We're truly blessed to be here to be able to attend this meeting. This pandemic has taught us so much, but most importantly, it has taught us to be grateful for what we have. And in fact, gratitude is at the core of man's relationship with Allah. Gratitude helps us focus our minds on Allah, something that has unfortunately become so difficult today on account of life's attractions and distractions. Showing gratitude to Allah is part and parcel of having faith in Him, and gratefulness to Allah may be expressed by the heart, by the tongue, or through good deeds and gestures. And true gratefulness by the heart is manifested through sincere belief that all the blessings we have, the known and the unknown, our very existence, our life, our body, our physical appearance, and all our abilities and accomplishments are from Allah. And the Quran says, whatever blessing you have is from Allah, Surah An-Nahl, verse 53. So with these few words, we can start the meeting tonight. I would just like to set the house rules, please. If everybody could please switch off their microphones and as well as their video. The speaker will have their video and their microphone on, and their camera on. They will share their screens. The meeting is being recorded, and we will be able to share the recording afterwards. If there are any questions during the talk, please place them in the chat group. In the chat, we will then try and answer them in the appropriate time when we get to that. We will also allow oral questions depending on time. We ask that everybody sits back, enjoys the talks that we have. We are going to have a jam-packed evening this evening. We will start our proceedings tonight with the first talk by Mrs. Rahima Token Mohammed, and her CV goes as follows. Rahima is an admitted attorney and a certified ethics officer who currently consulting for MVIP Incorporated, a law firm in Northcliffe that specializes in intellectual property and commercial litigation. And after working in medium to large law firms, she was appointed as the Legal Ethics and Compliance Executive of an accounting institute that is registered as an NPO. And one of her first projects required her getting the institute POPIA compliant. So she's been facilitating an introductory course to South African law for the Actuarial Society of South Africa for the past 3 years and lectures both law and commerce subjects at Monash. So her talk this evening, will be on POPIA, Let's Get Compliant. Can I ask Rahima to please switch off her microphone and start sharing the slides, and she's on the ball. There we go. So Rahima, please, if you can start your talk. Thank you.
Assalamu alaikum. I'm the human at the other end of this. I'm going to switch my camera off just in case we have a delay. But the slides do speak for themselves. And when we have questions, I'll come back on and then address you. So assalamu alaikum wa rahmatullahi wa barakatuh. Thank you for this opportunity to address you on the POPIA Act, the Protection of Personal Information Act. This evening, I would like to attempt to simplify an act that I'm sure has been giving some of you sleepless nights. Now, closer to July 2021, this year, you were inundated with email notices, WhatsApp group messages, prompting you to permit them to store your information. I'm sure your Truecaller app also worked overtime, keeping those horrid telemarketers at bay. And while you heard rumors of an act that could have a drastic effect on your business, on your business, on the way you run your practice. I'm trying to do the technology at the same time, math. Fast forward 3 months later. So, are you POPI compliant? POPI or POPIA may sound like a very cute act, or even your favorite fruit, depending on how you pronounce it. But the truth is, it may have disastrous implications if you find yourself in the unfortunate situation of a privacy breach. I'm in no way saying that this is an easy process, but I hope to assist you in simplifying the requirements. I'll take you through some of the important definitions as well as the 8 conditions that you must comply with, and then my 5-step POPIA compliance and details on your deputy information officers. As a medical practitioner, you understand confidentiality. So try to see this act as an extension of your responsibility. South Africa's privacy laws are based on European standards, and its importance is entrenched in our Constitution in Section 14. Parts of the Act were signed into operation in November 2013, but all of the provisions, mainly the establishment of the regulator, only came into effect on the 1st of July 2021. Now, I need you to remember that hot date at the end of the slide, because you have until February next year to register your information officers. So the rule is, if you are the head of the organization, you are automatically the information officer. And you being the head of your practice makes you the information officer. Just a note, the Act still requires you to register with the regulator. So you may be thinking, okay, so what if I don't register? Will I still be held liable? The short answer is yes, you will. So what is POPIA? Let us understand a few definitions and then look at the requirements of the Act. Now, a data subject, and I would suggest while we're going through these definitions, you make notes on who that is in your practice. A data subject is a natural person, so a living, breathing person, or a juristic person, a company that has personal information. In your practice, it may be your patients, your staff, even your suppliers. It is necessary to obtain voluntary consent from the data subject in respect of the processing of the information. As a holder of another's personal information, you are the person who determines the purpose of and method of processing the data subject's personal information. Hence, you are the responsible person. This is, of course, after they've provided you with uncoerced consent. When I say you, I mean you as the practice. You may delegate this responsibility to a deputy information officer, but we'll get back to that a little bit later. An operator is a person who processes information on your behalf, but is not employed by you. So examples that I could think of were medical aids, your accountant, billing bureaus, and practice management software. You may be an operator too if you are receiving information from another responsible party and processing the information. An example of that could be Lancet. Now, quickly, can you tell me more or less what you put into your forms? You know, when I come in as a patient and you tell me to fill out the forms, what type of things do you ask me for? Can I have like 5 different things that you ask for? You have to put your mic on to speak, sorry. What do you ask for?
Address.
Okay, address,
Phone
what
number.
else? Telephone number.
Telephone numbers, yeah. Contact details, that's true.
Okay, anything else? Is it pretty standard?
Date of
Yes.
birth.
Date of birth, okay, it is pretty standard. You might ask for the ID number or the date of birth, and those make sense. So would you ask for fingerprints or details of a person's education or their political affiliation or employment history? Now that doesn't make sense, right? Do you agree with me?
Yes.
Yes. So what is personal information? Now, I've provided you with this list, and these slides will be available to you. This is a list of what is considered personal information. It is important that you start reviewing your current forms to see, firstly, if you're asking for anything that is unnecessary, and secondly, to get consent for the processing of your patient's information. Now, I've highlighted two things on here in green because there's a specific clause that allows you as medical practitioners to be exempt from certain things. Let me just make this a little bit bigger. Okay, so Section 26 lists a prohibition on the collection of certain personal information, but as a medical professional, you are excluded from this prohibition in terms of Section 32. It's interesting to note that medical aid schemes and insurance companies also enjoy this privilege. So these are the, oops, sorry, because I want to use fancy stuff. These are the type of things that are normally exempt from asking in terms of Section 26. Religious and philosophical beliefs, but it might be important for medical purposes. Some religions don't allow you to do certain things, right? Race, ethnic origin, biometric information, health or sex life, trade union membership, political persuasion. Now, if you note from my previous slide, employees also may have an exemption, employers, sorry, because they need certain information in order to continue with the relationship that you have with them. Now let's look at the 8 conditions. So the Act specifically says these 8 things must be complied with. But let's translate that in order to understand what it means for your practice. So the first one, you have to have purposive specification. So ask yourself, why do I collect personal information? There must be a clear and lawful purpose for why you need that information. For instance, I need an ID number or date of birth because it assists me in determining if a person can give consent to medical treatment. I have listed a few other things on the slide, so employees, you may need to know who their next of kin is in case there's some emergency at the office, but you don't necessarily need their eye color or blood type. Patients, for instance, you don't require their fingerprints. And suppliers, do you have to know what their hair color is? Or do they need to know what your patient's hair color is? So remember, it must be clear and lawful at all times. Then processing limitation. Did you obtain consent? So just because you are a dermatologist and have your patient's details, it doesn't mean that you can add them to your marketing broadcast on the latest products that you have developed. You need to request information. Use the information for the purpose it was collected, no more. Another example. If you join a specialty practice where they have different disciplines in one place, you cannot share your patient's details with your colleagues. You need permission first. Finally, if you inherited a database, maybe somebody left the country and you're taking over the practice or going to another province, it happens. The best thing to do is for them to contact their patients and let them know they're moving on and they have details of another dermatologist, which they can provide, or if they want you to pass the file over, get permission first. So if you have inherited a database, you have a responsibility. It's not just the person who was the initial doctor who's handing over, but the one who received it. You need to know that there's consent. So if the previous doctor gave you the written consent from the client, perfect. If not, You need to contact each person on the database and notify them where you receive the information and request permission to store their personal information for a specified purpose. Then finally on this slide, information quality. Do you have the most updated information of your patient? This is important, one for Popi and two, just from a legal point of view. So for Popi purposes, the point of providing the medical scheme with information is to allow them to have a better idea of their risk. On a legal point of view, if your client's not paying, how are you going to find them? You need the most updated address in order to send the letter of demand and summons if necessary. Then when it comes to your staff, they say that the strongest chain is only as strong as the weakest link, right? Now, staff do pose a very special risk when it comes to running a practice. That's why it's very important that you train your staff. Now, from a staff employer-employee situation, it's important to get updated information annually from your staff, including declarations of interest. What if one of your staff member happens to be the relative, husband, wife, etc., of the one of your biggest suppliers? You need to know that. That's like from a legal point of view, but it insists on having updated personal information. When it comes to staff, we talk about something in law called vicarious liability. And that's why I say the staff issue is very important, because you may not want to have special insurance, but if they are partially responsible, whether they're deputy information officers or they have caused a breach of Popi, you are going to be the one held liable, you as the practice and the owner of the practice. So sometimes it's good just to look at various options available to protect the business. Then openness. Ensure that you are an open book regarding your privacy practices. Explain the purpose of collecting personal information and how long it will be retained. And that information will be stored in your policy, but we're going to get to the policy soon. Then individual participation. Do you permit data subjects to update the information? When your patients walk in and they're sitting in the reception area, is there an iPad or a tablet where they can update the information? What if a patient requires the medical report or tests for a second opinion, or they're going to another country or another province? Do you have that information readily available? And then retention standards. Now, the HPCSA lists specific time periods for the retention of data. Now, I stand to be corrected because the document I checked was last updated in 2016. But if you look at booklet 9, and you find this on their website, it notes that you should retain a patient's file for no longer than 6 years. So no less than 6 years, from date of discharge or death. 3 years after a minor attains majority, that means a child was with you as a patient and now is 21 years old, and a lifetime for a patient with mental illness. Now, I will discuss some of the storage options and how to go about that as the slides progress. Tell me, how would you destroy information? Anybody, how would you destroy information? Remember, retain to a certain point and then destroy. How do you destroy it?
Well, hard copies, you shred them.
Okay,
and,
perfect.
And electronic data, you make sure that they are securely deleted.
Okay, so just two things on that. You're absolutely correct. When it comes to shredded, you must shred it to a point where nobody can go back and reconstruct the document. They also suggest incinerating it, okay? And then when it comes to your computers, please, if you want to give secondhand PCs away, fine, but remove the hard drive because you can still get information off there. So it's important how we dispose of things, and all that again has to be listed in your policy. And the final two, so accountability. Is your information or deputy information officer appointed, trained, and fulfilling their responsibilities? Each area of your business must be considered, and potential privacy leaks must be noted and mitigated against. If you are storing data in the cloud, you need to check if the server is in South Africa. If not, you need special permission in writing to store the South African data subject's information across the border. So just having it on the consent form is not good enough. A special line in there stating that your information is stored on a secure server, which is held in Germany, for instance. It's across the border. Even if it's in Botswana, it's not across the ocean, it just has to be across the border. You need specific confirmation and consent for that. Train your staff. I would suggest quarterly, but that's just because I'm totally risk averse. But train your staff regularly. Make POPIA something everyone is cognizant of. Maybe add it to the KPIs for your staff and incentivize them for unique ideas to protect the patient's privacy and the business. Now, I'm not speaking bribery. I know it's their job, but this is an extra burden. So maybe a chucky every now and then goes a long way. When you do training, keep a register. When you train your staff, keep a register. Why? What if there is a Popi breach? What if an inspection is going to be taken place by the regulator? You need to have documented evidence that you have tried your utmost best to avoid a privacy breach. You must show that you've taken positive steps, and that's one way of doing it. And then security safeguards. When last did you perform a security audit? Now, hacking has become a scary reality in South Africa. I can't tell you what happened last night with WhatsApp for those few hours and Facebook, but everything was down. Maybe more people got more conversation in. But ransomware and its variants are forcing us to make better backups and have tighter IT security. So if you are making backups, make sure that they are secure. And if you have a server room or wherever you're storing your server, make sure that it is access control. Now, you don't have to have fingerprints and retinal scanners, and you don't have to go all Mission Impossible, as long as it's access control. So only certain people can get in. It's locked. It's either behind a gate or behind a door, but not everybody can gain access. If you're making backups, just remember, if it's going overseas, you need to have special permission. And always think about having a plan of action in the event that there is a breach. Now, I know it sounds very pessimistic, but you have to plan for the unfortunate event. That is risk management. Now that you have that in mind, I'd like to take you through a 5-step process, which I hope that I haven't simplified too much. But I think with all the different things that you have to comply with, I'm hoping to make it a little bit simpler for you. So, 5-step process to getting compliant. Let's go. Assess your business. Now you need to start taking a little bit of notes. Okay, think about what I'm saying and start writing down all those privacy gaps that you can think of in your business. So for this one, we assess our business. We have to look at internal and external stakeholders, as well as what you do with the personal information. Remember, only take what you need and keep it for the period that you need it, or that you should lawfully hold on to it for. Now, a good thing to do is to do a walkabout at your offices. And that's what I do when I go to a new client. I'm like, can I please visit you? I just need to check a few things. I'll give you an initial report, and then we can work on what your privacy gaps are. So you do a walkabout. You start at the entrance where the cars come in, and you go right through the office, reception, common areas, consultation rooms, accounts office. You go through it all. So let's look at some examples of how we collect it, right? Now, if we start at the gate, I know this looks like an accounting book, but just imagine for now, it's that large book or clipboard that the security guards have when you enter at your premises. especially if you're in an access controlled area, there's usually a security guard there. Now, why must we fill in information, including our nursery school teacher? That's absolutely unnecessary. It needs to stop. Perhaps your name and number plate and maybe your temperature now because of COVID, that could be sufficient. Some fancy places have disc scanners. So the security guard asks for your ID, that's a Popi situation, and then they click onto your disc on the windscreen, another Popi situation, and all the while you're thinking, oh, I feel so I feel like somebody's invading my space, but you need to get to the doctor, so you're like, okay, fine, just take the stuff. Your patient has the right to ask what they're doing with that information, how long they're keeping it, and how they destroy it. Now, you can get that information from the office manager, unless, of course, you own the building, then you should have a policy to state how long you keep that information. CCTV cameras. Now, it would be, it's not just courtesy, but it's good practice to at least have a sign saying, smile, you're on camera, or you're being recorded, because your picture is also personal information. The image, the video, and it's important that people know that they are on camera, and your camera should be situated in common areas as well. So you can't have it in the toilet and in certain places, maybe the consultation room, because the patient is half undressed or whatever. So you need to be cognizant of that, but you also have to note in your policy how long you're keeping that information, where you're storing it. If you're storing it overseas, you need permission for that. And you also need to say what it's being used for. So sometimes we keep that for maybe 2 weeks, I think a week or two, in case there happens to be a robbery or something and you need the footage. But you can't keep it forever and a day. It's not, that's not the point of Popi. Then your reception area. Now, do you have a high desk that blocks everything so that the receptionist can work freely at the bottom without showing any information? Does your receptionist discuss patient information on the phone in front of other patients? That's a no-no. Also, if the screen is not that direct and against the, facing directly to the receptionist, and it's on an angle, do you have some sort of glare protection that's going to stop peering eyes from seeing what's on the screen? Because it might be personal information. Do you have a day register? Imagine having a day register in a very busy practice and a couple of reps or a couple of other marketing guys walk by and they're like, oh, I want to see the doctor. They take a couple of numbers down because they need people of certain, they have their own spec of what they need, demographics, and they just walk out. They never see the doctor. You're not allowed to have a person's telephone number and all their personal details written down for everybody to view. An option, rather, is the QR code. Now, some of the hospitals have this. Instead of filling out those forms like they made us do when COVID just started, you go onto the app, or when you get there, you click on the QR code, fill out the form on your WhatsApp or on your cell phone via the app, and they have the information. Nobody else gets it. Then, is that how your desk looks? You're not permitted to have things laying around. I know you see one patient after the other, but it's very important that you have a system of clearing your desk between patients, or making sure that sensitive and private information is not easily available for anybody else to see. Am I taking questions now, Chair?
No, we'll take questions after the second speaker, but I've asked people to note questions if you don't mind.
Okay, no problem. So make sure that in your reception area, as well as in your accounts office, because that's another problem, and the consultation room, that you have locked cabinets. And that's also access controlled. That's a lot of stuff, hey? Like a whole mouthful just walking around your office. Now, some of us want to have an office where it's so open and free and has this feng shui. I think I'm pronouncing it right, not sure. But this whole idea of you must feel relaxed. But can you see, if I walk into this office, I can see everything on that screen. And if the doctor steps out for a moment, I have access to everything in those shelves because it's not locked. That's a problem. So it's important that in your consultation rooms and in your examination rooms, firstly, there's no cameras there, but also that your files are secure and access controlled. Your server might be in your office. It might be a habit to keep your server in your office. Make sure that only you have access to it. When you're not there, that you lock your door. Now, this walkabout is super essential. What I would suggest is I would walk about my practice if I were a doctor on my own, and then whoever I have as a deputy information officer, I would have them do a walkabout and then compare notes. That way we're checking and double checking that we've covered our bases. Step 2. Identify deputy information officers. Now remember, you are the information officer by virtue of the fact that you are either the head of the organization or you are the head of the practice, okay? Deputy information officers should be appointed based on their knowledge of your business. They should report directly to you. I know we have staff changes sometimes, so the regulator has this thing where you can update your details annually. It's important that they are registered with the regulator. Those forms are available on the registrar's website. Make sure that they attend sufficient training and understand their role. I'll get into that in a little while. You may consider having Popi champions. Now, if you have a very big practice and you have lots of things going on, you may want to ask various people to be Popi champions in that particular sector or area, and they report then to the deputy information officer, or you could have a few of them. So if in an organization like IMASA, for instance, you have your committees, we will have a Popi, maybe a Popi champion there who reports to a deputy information officer at each level, and then they then report to the information officer. That way you have tabs on what's going on in your entire organization. Now that you have done a walkabout and you can see certain gaps and you know who your information officer is, it's the person you can trust. They've also been through the business. They understand what Popi is all about. They've done the training. Now you need to address all those gaps. So check that you firstly have consent from all existing patients. When a new patient comes in, make sure that you have those clauses in. If you find, check with your cloud supplier. If they are not based in South Africa, you need to then add that special clause in there that asks them if you can store the information across border. There must be voluntary, specific, and informed consent. Look, I know it's like Jannah points, but you shouldn't be giving your patient list to the local masjid for a buy a brick collection. As noble as the deed, it's not lawful for you to provide the information and for them to take it. The patient must be informed when giving the consent. So the data subject must be capable of appreciating their decision to furnish the consent. This means that, for instance, if you are my son's pediatrician, you can't say, Qadir, can I store your information, Baba? If you smile broadly enough, he's going to smile back, but that's not consent. Minors are represented by their parents or legal guardians. You cannot force a patient to give you consent either to providing the information. So no undue duress. I don't suggest asking after anesthetic, administering anesthesia either. Step 4, collate your required documents. And this is probably going to be the most hectic part of everything. So the first thing you need to do is register with your information and deputy information officers with the registrar. Forms are available on the regulator's website, the POPIA and PIA regulator. You require a privacy policy to give your patients peace of mind regarding how you take care of the information. So this should be available on your website, and you must have a hard copy available at your practice. You need to have signage in your practice regarding the CCTV cameras. For staff, a copy of their rights can be displayed maybe with the HR policies in the kitchen or the staff room. If you have added a patient to a WhatsApp group, send out a message stating the intention of the group and that that if they want, they can remove themselves. But the thing with this is it's best to have a link where you send it to a person that you know who's saying, oh, I'm looking to get onto the doctor's WhatsApp group, for instance. So instead of saying, I will add you to our group as the receptionist, for instance, say, may I send you a link? And then you can join the group. By them joining the group, they are now consenting to be on, and that covers you. But if you already had a group in place, you need to just put out a message saying that we're just trying, and be very, I don't know, don't be too formal about it. Say that we are trying to be POPI compliant, or we're striving towards protecting your privacy. And we have noted that some of you were added to the group. If you do not want to be part of this group, you are very welcome to leave. But should you stay, that you have now consented to being part of this group. And you can also say what the group is all about. In case somebody was added, they didn't even know that, they mute all groups, and all of a sudden they start seeing these messages pop up when they're bored on holiday one day. So check your current supplier contracts also. Now this one here could also be a bit tricky. I've seen certain supplier contracts where they make it your problem to ensure POPI compliance, and sometimes you don't have control over it. So read through the current contracts you have to see if there's a POPI clause, and if you have new contracts coming, make sure that you're only responsible for what you can control. If you have requested and obtained consent for the onward forwarding of information, so if you're leaving the country or leaving the province and you handing over your practice to somebody else selling it, you need to then send that consent to the next party, or you need to at least retain it if you have now received the database from a third party. When you send emails, please, it's often that we send test results, or I suppose even a doctor's note could be personal information because there's a lot of stuff on there. Make sure that you encrypt the document that you're sending via email. There's another thing about emails. If you send an email, say I send you an email, you can't then forward the email to somebody else with my details on it. You have to remove anything that identifies me, and then you can forward it to somebody else. Because by not taking out my signature and all my details, it is a problem, because now you're passing on personal information. Please relook at your consent forms. Take the unnecessary information out and add a POPIA clause requesting consent. So I know I made it sound like it's quick and easy, but there's a lot of work to be done. And it doesn't end there. It doesn't end when you have ticked all those boxes, because it's an ongoing process. So you need to stay compliant. Now, deputy information officers should do continuous POPI training. The regulator sometimes offers webinars, so check their site regularly. Ensure that you have a hold on your practice in respect of POPIA. The regulator also gives guidance notes and sometimes free webinars, which just explain certain concepts. Please check now. Now, I know you can go onto a person's website and you can probably just pull off their privacy policy. But before you decide you're going to use some of that information, read it. Don't just plagiarize it, because you might be doing it for the state, for instance, and it's not for private businesses. Or it might have something totally absurd in there that has nothing to do with your business, and now you've opened a can of worms. Keep a privacy risk register. So if you have found that there were issues and you want to address them, write them down and then start working towards mitigating against them. So the information officer. Now, briefly, an information officer is a person in terms of Section 55 who is registered with the regulator. So there's just a few things they're required to do. They're required to encourage POPIA compliance. They have to deal with any requests made. So if somebody says, I saw the guy scan my license when I came in, what is he doing with that information? How long are you keeping it? Now, you can't roll your eyes and think, oh, such a Karen. You're not allowed to do that. You have to, as the Deputy Information Officer, explain, show your policy, and try to calm the person down, because they have the right to know what you're doing with their private property, their personal information. You have to work with the regulator. So any non-compliance with whatever the regulator is noting may result in a fine or even prison time of no more than 12 months. So it is a bit cumbersome to be a Deputy Information Officer. Ensure compliance with POPI. This must be done actively. Keep a record of all your training that you do with your staff and update the policy that you have. If you don't have a policy, make sure you get one soon. And maybe do an annual revisit on it to see that we're still complying with what the Act requires. And then finally, sometimes there are directives that are furnished from the regulator. So as prescribed, you need to do what they require. Then Section 56 notes that these duties only take effect after the responsible person has registered with the regulator. Now, I do want to just make another note. I keep saying I've said it's cumbersome. There are some serious fines. So the worst fine is 10 million Rand per incident or 10 years in jail. Now that sounds heavy. Like, who wants to be an information officer with that responsibility? And I have also seen what my other colleagues have said. Some colleagues are like, it's not you as the person, it's you as the organization. But the buck has to stop with somebody, and you can't put a juristic person in jail. So as the ultimate information officer, the owner, you are ultimately responsible. Now, non-compliance is dealt with in sections 100 to 106, and it lists a few things. So where you are being obstinate, you'll be guilty of an offense. Now, what is being obstinate? Any person who hinders, obstructs, or unlawfully influences the regulator, no bribery and corruption. A responsible party which fails to comply with an enforcement notice. Offences by witnesses, for instance, lying under oath or failing to attend hearings. Unlawful acts by responsible parties in connection with account numbers. And unlawful acts by third parties in connection with account numbers. Whoa. So only if you plan on doing something devious would you worry about these sections. There are also, under non-compliance, according to section. Okay, so before I get into what happens if there is a POPI breach, it says here under section 107, there's certain penalties that could be imposed as offenses if you do not comply. So I told you about the 10 million, which sounds so extreme, but the other one could be where you don't want an official, for instance, to come in and do a search and seizure to gain evidence against you. That would then get the maximum penalty of a fine or imprisonment for a period not exceeding 12 months. Sometimes they give both. So it's always a good idea to comply. Now, what if there is a POPI breach? Now, section 22 states that if personal information is destroyed, so you deleted it in error, or somebody hacked your machine and made it impossible for you to retrieve. So if it was lost, somebody ransomwared you, or acquired by an unauthorized person, somebody got it, whether it was through IT means or if they just physically removed files from your office, that would be considered a POPI breach. So what do you have to do? First thing, you have to inform the regulator as soon as possible. You then have to inform the data subject as soon as possible, and this has to be done in writing. So they give you various means. Sometimes you don't know who the person is. So instead of emailing them directly or sending it via post, you might just note on the media. Sounds like a wonderful PR situation, but you note on the media or your website that we've had a Popi breach, and we're still trying to determine who was which subjects or legal subjects or juristic persons were affected by it. Now, you can only delay this notification if there's a current criminal investigation that is ongoing. The information in this notice must allow the data subject to mitigate against risk or consequences. So is there ID out there? Oh, shucks. Am I going to be married to another person? Is there email address out there? So I must beware of phishing emails because somebody might have my email address. There are various things that can transpire as a result of information being breached. So it's best to give the information and say, this is what was taken or lost or stolen from me, and this is the information of yours. So it gives the data subject an idea of what to look out for. You must also show that you have taken steps to prevent a further breach. Very important that you get your security intact. Now, just before I take questions, I want to give a few tips. 1, verify any database in your possession. Contact any person, all the people on the database, and say, I have it, this is how I had it, may I please continue to keep your information? I'm keeping the information overseas and you need confirmation, so email them. A telephone call and email, that will work well. Have written consent from data subjects. Use QR codes for attendance, maybe at CPDs or IMASA, and where you had a day register, move over to a QR code. Most people have cell phones. Check your workspace. Are there Popi breaches? Ask each staff member to sit down quietly and look at their office. If somebody had to walk in, what Popi breaches are, what are potential Popi breaches? Consider potential Popi risks. So have an engaging discussion with your staff and your deputy information officer and your Popi champions, and come up with a list of what problems we have. We all have problems. What are the problems? And then solutions. How are we going to fix it? And in what period of time? And then also, not sure if you're going to go for this, and I don't know who has it available at the moment, but possible insurance cover for a breach of Popi. Nobody wants to be sitting with a 10 million fine in the worst case scenario. And finally, my hot date, which is the end of February 2022. That's the date you have until to register as an information officer. Okay, Jazakallah khairan. I know it was a mouthful. Let me see if there's questions in the chat. Okay, the first one. So I'm just going to speak, right? I'm not going to chat back. Can we be provided with the recording? Okay, I'm sure the recording will be available. I see it's the next one. Under the Popi Act, what is the age of consent for minors? Okay, so minors are any children under the age of 18. That is consent. I know when it comes to medical consent, it is a little bit different. Is there a standard consent form for medical practices to use as a guideline for one? Okay, I don't have a template available right now. I don't know if anybody else wants to share one to assist. But for when I speak minors, it's anybody under the age of 18. I am well aware of the Children's Act, which says certain children may give consent over the age of 12, for instance, to certain medical procedures, but not to surgery because they still need their parents, but definitely somebody over the age of 14, etc., etc. But for Popi, 18. That's why, for Popi 18. What happens with the COVID symptoms screening forms we have? What is in those forms? And do you need all that information? That's my question. I don't know if Wahida wants to elaborate on that. What is in that form and do you need all of that?
So according to what we received initially at some point, We needed to, obviously it's for tracking and tracing patients that were at the practice, and seeing whether, obviously, if we come into a contact with somebody that has COVID, to be able to contact that person, the people that were at the practice before that. So we definitely would need telephone numbers and contact details. So I'm not sure if there's a way around that in terms of COVID.
Remember, the idea is to protect personal information, but COVID is an extreme situation. It's out of the box, and we have to still follow other legislation. Everything else doesn't go on pause because of COVID. And now that we have this extra requirement to check and make sure that everybody else is safe, public policy will take preference. Therefore, you would be allowed to, whatever they require, they want a telephone number, an ID number, and your temperature, that is permitted.
Okay, I have just, sorry, one more question. It's not about the COVID thing. So we often deal with medical legal cases. That's with the Road Accident Fund, or with insurance companies like Discovery and Momentum, where the clients have a policy and then they are sent to us for an evaluation. So what I just wanted to check, so usually they do sign a consent either with their lawyers or with the policy holders, with the HR departments, to go ahead with the actual assessment. But part of the assessment sometimes requires us to contact the employers and ask a lot of information about that person at work. And I mean, a lot of it is it can be personal information about the person's behavior and conduct. So that isn't a problem. Do we need to get special consent from the patient before we do that?
Well, when they're signing those forms with the medical aid and those other agents, what are they signing in terms of the consent? If the consent is you are permitted to do all things necessary and ancillary in order for me to make my claim, etc. If they're saying that, it might be all encumbered in there. So it might be fine, but you need to have a copy of that as the person who is now probing to get information. So you have that consent. It's almost like a special power of attorney, so to speak, but if it stays well in that initial document where they're giving consent, because you cannot do your job without getting this information from certain people, right?
Yes.
So they need to explain that to the patient and say, part of it is, I'm going to be asking your employer certain questions. Are you okay with that? You know, that type of thing.
Okay.
Is that fine?
Thanks. That's fine. Thanks.
Now, Miriam,
thank you, Rahima. Thank you very much for wonderful talk so far. If there are any further questions, if they can please leave them in the chat so that we can get on to the next speaker, and then we will take the final questions towards the end, please, if that's okay.
Okay, that's fine. I was going to answer one last question, but if you want to move on, I'm fine with that. I'll address it later. One last one.
Okay, there was somebody who had their hand up.
There's still two questions, well, there's a few questions in the chat. Can I chat back maybe while the other speaker's on?
Please, if you don't mind chatting back, that'll be great.
Okay,
I just would want to try and get the main talks going while everybody's still fresh and they can pay attention to that. Shukr. Thank you, Rahima. We will touch base soon again.
Okay.
Okay, and our next speaker is Yasmina Frank, who is the CEO of the South African National Zakah Fund, one of the largest Zakah institutions in South Africa. And she was appointed in 2018 as the first female CEO of the organization. She holds accreditation qualification in Zakah management, social science, and a host of other degrees or qualifications. She has 25 years experience in the corporate world, where she's worked mostly in the financial services sector and at some of the top South African blue chip companies. She'll be talking to us today. I think important to note is that she was rated amongst the 300 most influential women in Islamic business and finance by Cambridge in their Women 2020 annual report. She'll be talking to us tonight about the POPIA compliance for NGOs and the journey that Sanzaf has had. Can I please ask Yasmina to unmute and to share her screen? The floor is yours, Yasmina.
Shukran so much. Assalamu alaikum, everybody. Bismillahirrahmanirrahim. Rabbi sharah li sadri wa yassir li amri wahlul uqdatan min lisani yafqahu qawli. Shukran so much for this opportunity. Assalamu alaikum wa rahmatullahi wa barakatuh. Yes, as was just mentioned, I'm going to focus a little bit more around the SANZEF journey, our experience. So we see POPIA implementation as a journey that we are on and seeking to reach that February 2022 date that Rahima spoke about. In her introduction, Rahima also mentioned, you know, this is something that has given many people sleepless nights, and I echo those sentiments. When we look at the implications of POPIA for ourselves as SANZEF, as an NGO, it did give us some palpitations, and I'm sure the medical fraternity would understand that. And our compliance team started tracking POPIA years ago, and there was just so much happening, and we needed to understand that for ourselves. But initially there was a bit of resistance. So we were all asking the question, does POPIA apply to us? Does POPIA apply to non-profit organizations? And the simple answer is yes. Is there a question? Okay, and so we asked ourselves, so if the answer is yes, it applies to NPOs. Sorry, I'm picking up some feedback. Is it myself or is it something else? Okay. So what does this mean? It meant for us that as an NPO, we need to lawfully process personal information in accordance with the provision of the Act and all the other lovely things that Rahima spoke about. So there was no way for us to get away from it. And then we even asked another question. So are there any special concessions for us? As NPOs, we always like to be treated differently. You know, we get tax concessions and all of those things. And the answer was no. So essentially, it is a responsibility for ourselves to become familiar with the requirements of the Act and manage our very limited resources accordingly. If you look at the IMA as an NPO, I think, you know, just as a structure, I think you would relate to when I speak to the limited resources, because I'm referring here to both financial resources and human resources. And you compare yourself perhaps with a big corporate like a Vodacom or an Old Mutual, and you try and compare the resources that they can throw at something like this to become compliant and what one is able to do as an NPO. And so when we talk about sleepless nights, it's all related to that aspect of it. But so we embraced this and we felt that, you know, let's plot the journey for ourselves. And this is basically what I have on the screen, basically our processes that we went through and how we analyzed what was required into a roadmap for ourselves. So some of the things we went through is the information gathering process and getting to understand the Act. So exactly what Rahima was doing now, we had a number of presentations that took us through the Act, get to understand not just what the Act itself contained, but also what that meant for us as an organization. We also obtained guidance, and here, obviously, as an NPO, we had to go with those, you know, kind of people who that would give us free advice. And I'm hoping I get some free advice as well from Rahima. If anything I say here requires correction or anything that SANZEF is doing that is not particularly correct, I'm hoping that she would set straight at a low fee. Yes, we had to obtain guidance, and through that guidance, there was an evaluation of those implications that we had taken from our understanding of the Act. That led us to prepare an implementation plan. So we said, we understand the Act now. we have evaluated what it means for us. So now let's get into the parts where we have to do things. We started off with developing a SANZAF Popi internal policy, and Rahima referred to that internal policy, which is important because I also just made some more notes to ensure that, you know, specifically when Rahima was talking about the destroying information or data, the method of destroying, just to make sure that we articulated exactly the way she was saying. It is in our policy, but speaking about shredding hard copies to the point where it cannot be reconstructed. So we have the internal policy now, and then we had to make the appointments, the information officer, the deputy information officer, and that we obviously submitted to the registrar. We followed that through with a data mapping process that says, where does all our data sit? And I'm going to talk to the different sets of data that we have, and maybe you can relate to that in the next slide. And what we then got was a compliance in process letter from the company that's assisting us to implement our plan. And what this is helping us is, if we should get an audit by the regulator, then we have a document to show good intent that we are getting ready, and we've done some of the action items, and we can prove that there are still some things that we're doing, but we have the roadmap. We also went through intensive staff awareness and training, and I really concur with Rahima regarding the continuous training. So do it quarterly at least, because there is so much happening in the organization relating to the staff's own function, the role that they've been appointed to do. And, you know, as an NGO, you stretch every resource, financial resource, human resource, stretch it as much as you can to derive the greatest value add. And then you layer that on with something that a staff member may even think it's not their responsibility. So a lot of staff awareness and training need to happen. And then we attended to the compliance notices, to the agreements and the consent forms. And alhamdulillah, that is all done and is available to all staff as and when it's needed, particularly when we're talking to partners and stakeholders. Consent forms with staff was already done. Compliance notices all up in all our offices, but also in our meeting rooms where our caseworkers meet with beneficiaries. So those things are in place. What we are currently doing now is the stakeholder mapping. We are reviewing all our policies. So when we talk about policy, I'm here referring to have a finance manual, and it guides the team in the finance department, guides them on how to process a payment, it guides them on how to pay a service provider. We are reviewing each step to see how that is impacted by the requirements of POPIA. So that's currently underway, and it is a process because, number one, we don't have a dedicated resource. This is added to our functions, and so we have to manage our time very creatively to ensure that we can get through this within the required time. And obviously, we're wanting to continually monitor our compliance going forward. And here, we are currently sitting with a business case that we're wanting to make to the board to ask if we can look at perhaps getting another resource to perhaps even mornings only for a week and help us with the continued monitoring, where it is that person's full-time responsibility. So as the information officer myself, it is a huge responsibility, but you can imagine as CEO, which other responsibilities I also have. So it's not ideal, but given the fact that we are an NPO, that's the kind of challenges we face all the time. In fact, even with employment equity, in terms of putting our employment equity plan together, we don't have dedicated officers. So those kinds of functions, whatever regulatory requirements there are from government, and we're wanting to comply because we have the MPO status, and we obviously do not want to lose the status, and when we remain compliant, all of those functions still have to be complied to. And so we pile on and we pile on, and then you worry that some things may fall through the cracks. But with this one, given the activities and what can happen when there's a breach, we have prioritized Popi and getting the culture changed in the organization where that is concerned. So an important process when we spoke about our stakeholder mapping, we mapped out all stakeholder groups that we could cluster together, and we didn't want to go too far because we looked at some that we can cluster together and identify what is it that we have in place that needs to be amended. When we look at beneficiaries, this is the key category that we serve on a daily basis. So we have case files for every beneficiary, and I think there's perhaps some thing that the medical fraternity can relate to in this instance, in that we probably have a file for every patient. So we have case files. We know that on the outside of the case file, the cover of the case file, a lot of the data is written on the outside of the file. So if that file was on the desk of the caseworker and they're seeing the next beneficiary, that's a breach. Also, we're looking at case files and saying all the blocks on the cover page, is it asking the questions that we really need, or were we just at the time of designing this trying to gather as much information as we can for whatever eventuality may come up? So Popi is now asking us to probably build a different kind of behavior and saying what is the absolute information that we need and what don't we need. So that is being impacted. So also biometric information. So in some of our offices where we have cameras and we store that information, so the picture of a data subject, that is also part of their personal information. And also if we look at employees, also their biometric data in terms of their thumbprint from the point of view of, you know, clocking in and out. So those kinds of things we started doing when we did the mapping. We also have verifications and referrals when it comes to beneficiaries, and this is where we have to build in the process of consent. Oftentimes we see a beneficiary and the nature of the case is that we might have to refer, for example, a abused female to maybe a safe house, and we have to get her consent to be able to contact that safe house and to ask, you know, whether there's space and give the information so that the beneficiary can go there. So the whole extracting the consent must be built into that process. Also, we have banking details for beneficiaries in financial cases where we are assisting perhaps with debt that they have or rental or whatever the case is. So that's what we mapped out. When it comes to donors, most of our activities related to donors is issuing receipts for funds that they've paid over to SANZAP. So the receipting process had to be mapped out. We have online receipting, but we also have paper documents. So that had to map out. Also under Section 18A, a lot of our donors request such a certificate for tax rebates. We have the marketing aspect for opting out. That is an important component that we need to build in. Interesting thing came about when we looked at how we mark to our donors, even start thinking about our annual report that we put together. You know, we tend to put pictures in our report to speak about the success stories that we have. And now we need to build in the consent of when you're taking a photo of a beneficiary and saying, you know, this person was a bursary student and has now secured a job as a accountant, whatever the case is. And so we needed to map that out. When it got to our employees, we needed their employee consent form because we contain their personal data. We even have some of their family details because it relates to their employee benefits, where they might have listed a beneficiary in the event of a death or an emergency number in the event of injury on the job. We have biometric and health information as well. So that is how we had to map out our employee process. When it comes to suppliers and partners, and I think Rahima touched on this, something like an audit firm, like so our auditors, we need them to obviously sign. At the moment, we only have confidentiality agreements in place. And now we have to get contracts in place for the protection of our information that would go to them. But other suppliers would be a payroll supplier, it would be cash and carry, who is providing us with products for our food air feeding schemes or even our food parcels. So all of that where information would maybe go from the organization or individuals where we're doing maybe food vouchers, and that food voucher is being redeemed under a certain reference number, and that reference number is linked back to a person. So if I could just perhaps relate an example, during COVID, we had to distribute 10,000 food vouchers on behalf of the Solidarity Fund. But the Solidarity Fund wanted to vet every beneficiary to ensure that there wasn't duplication with other distributions that had happened. So 10,000 names had to go to the Solidarity Fund. And we had to put a data protection agreement in place between ourselves and the Solidarity Fund. And that time was prior to the 1st of July, but it was a useful exercise nonetheless, because it got us ready and it got us thinking along the lines of protecting our beneficiaries' data. Another stakeholder that we might not always think about is our board members. So being an NGO, often your board members are volunteers. They're not covered by your employee contract. And so your employee consent form don't really cover them. They're board members, they serve in a voluntary capacity, but they do have access to data through reports, and even some of them being champions on certain projects and programs. That's an important consideration to make. How do you, ensure that your data is protected when it's shared with a board member for the purposes of them helping you make decisions for the organizations going forward? Volunteers is a big component of our resource base, but they also have access to information, specifically if they're assisting with a distribution campaign, or even if they're assisting with a income campaign in terms of us marketing. So there too, we have to get contracts in place for us to, ensure that they understand the POPIA implications and is part of the protection of the data. So just some of the things I thought I'd just speak through. This big document with some of the red writing is our POPIA schedule for implementation. And so we track everything and we've listed everything that we still need to do for the next couple of months. And this is reported to our board, our monthly board meetings, just to ensure that there's some accountability for the progress on achieving implementation. And just the proof of, sometimes we wanting the regions to, because we have 29 officers, so managing that is our challenges, but we ask them to send us, photos of the privacy policy either up on the walls or in the caseworker's office. And then also, I mentioned earlier, our protection of personal information. We have our internal policy document. Every staff member has to sign to say that they've received it and have read it. Also on our website, we have our privacy policy on the homepage. And if we do anything that we mail out, we ensure that the link on the email is back to this website where the full policy can be read. So these are just some of the things that we've managed to deliver on. But to just kind of summarize, there were some challenges that we faced. Initially, a lot of information overload. There is just so much available on Popi, videos that you can watch. YouTube which has lots of videos for you just to get familiar with it. Sometimes with information overload, it just makes you kind of anxious because you're not sure if you are completely covering everything. Then also lots of consultants and advisors knocking on our doors, and we had to filter through in terms of, you know, cost and affordability. So that was another challenge that we faced. And it took us a little while, you know, getting approval for, you know, which consultants and which advisors and where we're going to get the money from, because as always, the resource demands for funding and resources is always something that we have to face. And also then resource requirements, as I mentioned earlier, who do we assign all these tasks to and how do we get it done? That was one of our other challenge. And with staff awareness, it's, you know, it's the unlearning and the relearning. So getting in the habit of when you stand up from your desk that you lock your door, or when your next beneficiary comes in for a session, that you have a clean desk. Even the simple things that we spoke about, Rahima spoke about in reception. So there's a lot of unlearning that needs to happen and some relearning that needs to happen. Another challenge that I mentioned earlier also was the amendment of our policies. So we have an HR policy, finance policy, a welfare policy, IT policy, income policy, and going through each one of those, because these are the Bible on the desk of the staff member. If you're in HR, you need to have that policy at your desk. If you're faced with a particular challenge, you can refer to the policy. In finance, the same, welfare, income, all of it the same. So we encourage our own team to familiarize them with this document. And so it is the perfect document to list how to go about the additional steps that will ensure data security. In our whole stakeholder engagement process, so now speaking to donors and beneficiaries, in talking to them about obtaining their consent. And suddenly, when you speak to somebody about consent, there's immediately a, what is this about? And there's immediately a suspicion that you get when you say to a beneficiary, you need to give me your consent for me to take it maybe to a referral or something. And so you have to almost educate both donors and beneficiaries who are not familiar with POPIA that this is in their interest and it's about civil liberties and protecting, you know, personal data. So there's a little bit of that engagement that we're going through, and it's continuous. And then also in terms of the penalties and liabilities, currently chopping around for insurance to see, you know, if we can cover ourselves in the event of a breach. And just also something to talk about, I just forgot to mention, under the staff unlearning. So we painted a scenario for staff and we said to staff, imagine there's a theft in our offices and we come in the morning and one of the filing cabinets is open and we can see that half of the files are missing. And I think for the medical fraternity, it's probably a similar scenario. Come into your office, filing cabinet is open, lots of other things have been taken. Those files that are missing, you need to inform the data subject, as Rahima rightfully said. But do you know which files are missing? Would you know which of the patients, or in our case, which of our beneficiaries' files have been taken? Do you have some kind of key document that lists all of those files? Because now you can say, oh, it looks like there's a whole lot of files missing. You have an obligation to inform the data subject that there's been a breach. But if you don't know whose file was in that cabinet, who are you going to inform? So that's another learning, a relearning process of capturing in a different document which files goes into which cabinets if something like that should happen. So all of this is about kind of that constant awareness to ensure that everybody understand the implication of this. So I think where we are now as a way forward, implementation, compliance, monitoring, and then risk management is what we are focusing on now. Definitely, it's about managing our resources effectively so we can achieve compliance. It is about, you know, taking this as not just something that we have to implement, but it's an entire culture change. We still have lots of paper documents. We haven't digitized much. there are some processes in SANZAF that has been digitized because there's so much paper and there hasn't been that focus on protecting information. Is a huge culture change that needs to happen. And also, getting away from the whole checklist mentality that is just a matter of ticking these boxes and getting it done, but more so of a mentality of these are the things that we need to do and have it continuously on our list. And then we, from a risk management point of view, are committed to internal checks, and we're doing our own internal checks because, as I said, we have quite a number of officers and we can't wait for a breach to identify that there is a gap in the system in one of the offices. So we'll do internal checks and random testing for compliance. And then internal reporting, we need to satisfy ourselves. So one of the standard items on the board agenda, board meeting agenda, is a report on how we are doing on Popi. So that is our kind of internal controls that we want to put in place to ensure that there is ongoing progress. And alhamdulillah, that's in our journey. And I think it's been enlightening in the sense of understanding the importance of data, but it's also important from the point of view of, are we getting this right and can we afford a breach? And how do you manage an organization of this size and this scale, and ensuring that every one of the 110 to 115 staff members that we have understand their role. But there's a sense that we've embraced this, and so inshallah we hope that our journey will continue and that we'll eventually get there. Shukran.
Shukran. Thank you very much, Yasmina, for a really wonderful talk. It just shows the amount of work that we have ahead of us as the IMA, as an organization. But even then, in your journey, there's a lot that can be learned from individual practices as well. We have time to take questions. I see that the chat has been going quite well. There's lots of questions that have come through and have been answered. Is there any, can by a show of hands, if anyone has any questions, if we could, we can engage our two speakers. There is one question on the chat, have to get consent individually from each person, cannot get a collective consent. And that is in response to if the mosque has got a collection or sorry, if they're collecting names, they need to have individual consents, not just a collective consent from everybody, if I understand that correctly.
Yes, Mark, I answered that question. They can't get a collective consent. We can't make mashura that way. It has to be individuals because it's their personal information. And then Shanaz Mohammed asked, do we have to get consent individually from each person? Yeah, okay, so that I think that was answered actually.
Yes, that is answered. Shukr, thank you very much, Rahima. Are there any other questions? I think the important thing that we need to note is that going forward, there needs to be every practice, I'm sure, has started, but there needs to be a collective assistance, and this is where the IMA comes in. If anybody has already done a lot of the work, I know there was a question about templates and correct templates for practices. If you have anything available, make it available to us that we can, obviously non-personalized, POPI compliant. We can make it available to everyone else who might request that, just to make the steps going forward a lot easier. This is what we're here for. This is what we're here as a collective, to try and make life easier for everybody. Are there any other questions that anyone might have for our two speakers? I see we have another question on the chat group.
Okay, if somebody makes information public, so it's on LinkedIn, Facebook, it's available to the public, then they themselves have made it public. But in the past, where somebody puts a photograph of you on Facebook and you're not happy, then you report it, right? Because it's your information. So yes, if if it's known to everyone, then it's not really personal. I think we should go back and look at our profiles and see how much information we actually give out. Some people have their CVs out on LinkedIn. I think that's very dangerous. What information do you need on your medical certificates? Well, that would be what the I always forget this acronym.
HPCSA.
Okay, so we need to find out what they want on the medical certificates. I don't think that, not everybody's certificate looks exactly the same. So obviously your heading on the top with your information, your practice number, so people can see what the professional is. But in terms of me as the patient, so my name, so my company can maybe identify me, and the bare minimal. Some people just say medical condition, and then you contact the doctor and they tell you, they give you more information. So you don't have to put my ID number down and all that information, unless of course there's more than one person with the same name at the premises. Then you might say, just put my date of birth there so they know who we're talking about. You know, like an identifier that is not too much.
There is also an exhaustive list on the HPCSA of exactly what is required to make a medical certificate compliant, as it were. So there is a list of that on the HPCSA website as well. I think the important thing from a POPIA Act is to ask the patient as well, if I'm not mistaken, you need to ask them, if I disclose this medical condition in this form, are you okay with that? And that's particularly when it comes to certain jobs and mental conditions. You know, you can just rather put medical condition, and if the patient, if the employer then requires you to discuss it or wishes to know more, they can phone and discuss it, but there too, permission from the patient is required for you to be able to discuss that. So you don't have to put the exact details on the medical certificate, as far as I understand. You can, you know, the usual URTI, LRTI, if they've complained of it to them, that's the reason the employer sent them. But if it's other things, then you can actually just put medical condition. You don't have to put an exhaustive list of medical conditions on there.
I have a question for Rahima, if I may. This
Yes,
is my
ma'am.
way of trying to get free advice. Rahima, just a question. Is from a POPI perspective for an NGO like ourselves versus a medical practitioner, is it correct in saying that consent can be verbal for most industries, but for the medical fraternity, it has to be in writing?
No, not for POPI purposes. For POPI, it must be in writing.
Okay.
So even for an NPO, you have to have it in writing. Yasmina, keep my number. We'll chat because I have some notes that I made for you with regard to your presentation and stuff in there. Maybe it can assist. So if you permit, you have my number, just keep it and then we can chat. Okay, so I'm asking for permission now already.
Yes. Are you giving me consent to
I'm
contact
giving
you?
consent. You can contact me. I'm available.
MashaAllah. Jazakallah, Rahima.
Okay.
So I chatted yesterday to Rahima about exactly this, and Rahima will make her details available on the chat, as well as a presentation available to us so that we can make that available to everyone else. If anyone wishes to then engage Rahima in trying to get their practices POPIA or POPI compliant, they can certainly get in touch with her, and then she can you know, discuss the business proposal to you. We've not concluded it properly yet, but just so that everybody is completely aware of it, if there are costs involved, that is for your own pocket, and the IMA will get a percentage, inshallah. Rahima, we sorted that yesterday, eh?
Yes, I mean, I got confirmation on that as well. So
okay, great. Shukr. Thank you very much. If there are no other burning questions, this talk will have been recorded and will then also be made available to the people via email, and your CPD certificates will be coming through shortly within the next week or so. There's one last question from Deva. What happens when there has to be a nurse present when an intimate exam has to be done? Do I get the consent from the patient that the nurse has to be present?
What do you normally do in that situation? I think it's more medical thing than a POPI thing. I think generally you ask permission generally? Just, I don't know. Can somebody help with that?
I would say yes. Generally, you do ask permission of the patient, and you say to the patient, for their protection as well as yours, you are having a nurse present. And you could, if you don't want to use those words, you can say that you need somebody to assist you in handing you equipment. Then they can give their permission. So you must ask permission. I hope that answers the question, Deva. Okay, if there's no further questions, then I'm going to conclude this evening session. Just before we do conclude, Webima has taken off, and we have had quite a few very, very good, and this I credit as very, very good as well. Webima is in the recent past. On the 20th of October at 1900, 7 o'clock, CPD accredited, there will be another Webima, and it will this time be on asthma. Dr. Ishmael Sikandar Kala, the future of asthma management, more choice, better control. And Dr. Ahmed Manjra will talk about urticaria, more than an itch, new advances, and that is sponsored by Novartis. The links and the information will be distributed as it normally is. If anyone wishes to, and they're not getting any of these informations or any of the little bulletins, please leave. I will leave the chat open for a bit. Please just leave your contact details. We'll take a note of it so that we can actually pass it on to you in that way as well. Thank you very much, everybody. Can we conclude with Surah Al-Asr? Bismillah ar-Rahman ar-Rahim. Al-Asr. Inna al-insana lafi khusr illa alladhina amanu wa amilu salihat wa tawasaw bil haqq wa tawasaw bis sabr. Shukr to all our speakers. Shukr to everybody who has made the time available tonight to be here, and to all the staff in the background, to Khida, Kashifa, and everyone in the Webima office. Thank you very much for making this a good and a successful meeting this evening. Thank you, everybody. Assalamu alaikum.
Wa alaikum salam.
Wa alaikum assalam wa rahmatullah.
Thank you for informative. Thanks to the speakers. Good night.
Thank you, Priscilla. Good night, Priscilla. Thank you for being here.
Thank you.
Thank you. I'm leaving.
Thank you, Mohammed.
Thank you.
this? What? Amen. 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 Watch that.